The Mental Capacity Act is a piece of legislation designed to empower people to make good decisions. And its fundamental ethos, its principles are really sound today, and I haven't come across anyone who disagrees with them. But the implementation of it isn't understood and is made overcomplicated. And I think if there was one thing that I would get everybody to do, it would be to listen. To listen to the person in front of you, listen to what they're saying, and then tailor whatever information you're giving them to what they're telling you that they need to know. There are lots of complications with the Act when you come to implement it out there because of time pressures. The NHS and the social care system are really working under huge time pressures, and yet people need time. And they need a calm environment, not a pressurised environment of an A&E. Next of kin don't understand that they are not the proxy decision makers unless they have a lasting power of attorney for health and welfare decisions. So again, there's a lack of understanding out there about actually what people can and can't do.
When we make a decision on behalf of somebody else, we use the best interest test, and the law and practice say the gold standard of making decisions in that way is to involve other people in a shared decision. And we use we formalise that in the process of shared decision making. So we get around a table with the patient's family, perhaps, or the patient's friends, or patient's children, and the doctors, and they sit down and try and reach a consensus between one another. Unfortunately, the way that this consensus works isn't really very well explained, and that was sort of one of the things I talked about in my talk. In an ideal sense, we might want to make the consensus something completely free and equal between the two parties, and we might want to sort of abandon our own personal interests at the door and kind of just have a free-ranging discussion. In practice, people come with their own baggage to these sorts of discussions, and it's not really clear whether they should be guided by the doctor, or whether we should just allow families to entirely drive the discussion. And it's also not clear how much the patient remains represented in those discussions, because the patient, of course, is the only one there without a voice. So in the seminar, the reason I was bringing these issues to light is because the sort of concepts that get used within best interests and shared decision making, there's a lot of academic and philosophical sort of backstory to them. There's a lot of that they involve a lot of concepts that, when you look at court judgments, aren't necessarily addressed, or when they're addressed, they can be addressed in sort of quite an eclectic manner. So part of the problem is that there doesn't necessarily seem to be a development through these projects, through these different concepts within court judgments over, and so I looked at two particular judgments sort of over a sort of that's placed 6 years apart, and both of them are kind of calling on these concepts in a very eclectic way, and it stops the law from being consistent, and one of the chief aims of the law is to be consistent so that outsiders can see that you follow the due processes that you're supposed to follow. And so when judges don't fully engage with the philosophical underpinnings, I think you risk having law which doesn't end up making a lot of sense.
My talk was about the obligations of the NHS and when they have to fund a particular treatment, and in the context of today, that's potentially expensive end-of-life or life-saving care. And in the event that the health or the NHS declines to fund such treatment, what a patient can do to challenge it. And the focus of the talk was on a process called judicial review, where an application is made to the High Court, and a High Court judge decides on the lawfulness of the decision. And historically, the courts adopted a very non-interventional approach, where they were very reluctant to intervene and to tell a health authority how to spend their money. They would say, we're not qualified to answer these questions. We don't expect the health authority to turn up to court with its account books and say why one patient can't get this treatment if we pay for that treatment. and that was always the position. Then we had the Human Rights Act, which came into force in 2000, and that raised a question mark as to whether the right to life was applicable in those decisions, and that health authority had to take a patient's right to life into account in deciding whether or not to fund a potentially expensive or not expensive end-of-life or life-saving treatment. And my talk finished with saying that until relatively recently, that argument didn't probably carry a great deal of weight. But there's two recent decisions, one from the European Court called Watson United Kingdom, where the Strasbourg Court found that a reduction in life expectancy, which has been caused by the state, can amount to a breach of the right to life. And another case, which was my case, called Raybone and Pennine Care, where the Supreme Court said that the door is not closed as to the type of cases where the right to life might be engaged, and they approved the Watts decision in that case. And in Watts, the court said if there is clear medical evidence that the actions of the state, so that means the NHS in this context, have reduced somebody's life expectancy, then that can amount to a breach of the right to life. So now I think it's reasonable to mount an argument against an NHS commissioner who declines to fund expensive treatment at the end of somebody's life or life-saving treatment to raise that right to life argument. And I think it would make it much more difficult for them to defend that decision if you brought that point and relied on the cases of Watts and Raybone and Pennine Care.
So I'm going to be talking today about long-term care issues and mental capacity issues, particularly with those individuals who are elderly and frail, and also looking at the interaction between those individuals and their families and people who are interested parties. So I'm going to be looking at people with dementia, we're going to be looking at who should be managing the finances, whether the family are perhaps the best people to be doing that, or whether their own interests are going to be overriding the interests of the person who's elderly and frail. And wanting to engage with people today that lawyers aren't necessarily the enemy. We can help in certain situations. We can make things easier if we're brought in early enough. So a lot of my work is, I'd like to do a lot of planning with people, but we can help manage a crisis. So that's a very broad sort of talk about what I'm going to be doing. I can talk about sort of how we've helped family members. We can help family members with looking at funding issues, claiming NHS continuing healthcare funding for an individual. Just to give you an example, I was approached by a financial advisor who asked me to contact the local clinical commissioning group. He had a husband and wife client. Husband had been diagnosed initially with Parkinson's and been told that he needed to go into care, and the care was going to cost about £1,000 a week. We wrote to the clinical commissioning group and we asked would he please be assessed for what's called NHS continuing healthcare funding, which is where if somebody has health needs and they are primary health needs, then the NHS will fund that care. They did the assessment and they found out that he had something called parasupranuclear palsy, which is a pretty nasty degenerative illness. And they said, yes, actually this falls into the NHS budget. And there's one care home that we can find for him, and it costs £1,600 a week. We are now paying that. So it's a huge relief to the wife to say, I don't have to find that money anymore. So that's one of the things I've been able to do. Another example of how I can help families and individuals is where perhaps the families have not dealt with finances properly. So money's been taken from an elderly relative, there may have been financial abuse, somebody may have thought that they were entitled to inheritance early. So, I can't believe I'm writing out £1,000 a week care fees, I'll just write myself some cheques. It happens, and so I can help with people with looking at that sort of work. So actually keeping people on the straight and narrow, making sure that the law, which applies to everybody, is applied to the people who are doing this work themselves.
The subject I wanted to talk to people about today was the developments that I perceived in the assessment of mental capacity. We have the Mental Capacity Act, of course, which came into effect mostly in 2007, but is actually 10 years older than that in its genesis. It didn't apply to criminal law, and the Law Commission were asked to look at the criminal law in relation to capacity and to examine insanity and fitness to plead, the two issues that were relevant to criminal jurisdiction. The Commission reported in January this year, so just about 6 weeks ago, and they made some recommendations and came up with draft legislation which would determine how people were assessed as capable of either standing trial or potentially being able to plead defence of insanity. The Commission has, in its consideration, departed from much of what was in the Mental Capacity Act in terms of its assessment criteria, and that, I think, is the interesting point, because it may provide an indication as to the direction that any future review of the Mental Capacity Act will take, and how those changes may well be formulated in assessing capacity. There seems to be a fairly substantial body of opinion that the current test within the Mental Capacity Act doesn't actually work that well, and the view is that this is going to come back for review and reconsideration and perhaps an amendment relatively soon.
So I work in medical ethics and law at the University of Bristol, and a great deal of my work looks at the bioethical questions around end-of-life decisions, and there are a whole range of end-of-life decisions, from the big controversial questions like assisted dying through to everyday palliative care decisions about withdrawing treatment, symptom control and the like. And there are big ethical difficulties here, big ethical questions around should our ethics, our policies be guided by autonomy and choice, or by an obligation to remove suffering, or by the importance of life itself. And you see all of that playing out in our laws and our policies and our practices at the moment. But there are some tensions there. So I think it's important that we all, whatever we are, whether a professional in law, in healthcare, or a patient, think about the ethics of this. In the words of the Dying Matters Coalition, dying matters, let's talk about it. So in our discussion with the audience today, it was very important that, number one, we use a real case. So it makes the story come alive, it makes the issues come alive. Everyone will have their views, but this is something concrete that you can reflect on. And what struck me is people's views do change. I take different votes at different points in time, and so people do find themselves thinking what they thought earlier is no longer where they are now. That's common for most of us, I think, particularly on values questions. The big theme that emerged, I think, was the importance of choice, and then trying to work out where the boundaries of choice are, and what happens when choice comes up against different ethical values. As I say, dying matters, let's talk about it. Let's keep talking about those issues.